Slip and fall and trip and fall cases can be tricky. To win a case like this, it's crucial to have the necessary evidence to prove liability against the property owner of the property in which you fell. I've handled countless fall cases over the years. For several years after I got out of law school, I worked on behalf of insurance companies defending fall cases in court. For the last several years, though, I represent the Davids of the world against the Goliath insurance companies and corporate defendants doing what I love in advocating for injury victims. In this video, I'll be discussing what is needed to win a slip and fall or trip and fall case. First, don't expect that the insurance company or large corporation you're dealing with will make you a fair offer. The insurance company or large corporation you're dealing with for a slip and fall or trip and fall case is a business looking to minimize the amount they have to pay out to injury victims. Also, it is crucial that you preserve your claim by filing a lawsuit before the statute of limitations expires in your case. In Kentucky, the state I practice law in, you only have 1 year from the date of your fall to file a lawsuit. This may seem like a lot of time to you, but it's not when it comes to an injury case. A lawyer or insurance adjuster oftentimes won't even know the accurate value of your case after a year if you sustain significant injuries. That's because it's nearly impossible to determine the value of a case until an injury victim is either done treating or reached maximum medical improvement. So don't wait around expecting the insurance company to make you a fair offer. Take action much sooner than that. So, in order to make a significant financial recovery in your case, know that your fall must have occurred on another's property. I've personally handled claims for falls that occurred in big retail stores, grocery stores, gas stations, restaurants, apartment complexes, hotels, hotel showers, sidewalks, and parking lots. If you have fallen on a property that is not your own, you may be entitled to a settlement if you can prove the property owner or anyone with control over the property was negligent. Just because you fell and were injured somewhere, however, does not mean the property owner is at fault. You must prove they were negligent. So how do you prove the property owner was negligent? Well, you must show that the property owner breached a duty of care they owed to you. For instance, in Kentucky, where I practice law, business owners of grocery stores, retail stores, restaurants, hotels, or any similar business that invites the public into their business have a duty to inspect for slipping or tripping hazards on the business premises. If they act unreasonably by failing to discover or remedy a defective condition on the property and you sustain a fall due to the defective condition, you may be entitled to a financial recovery against the business. This is why it is crucial for you or a loved one to take photographs of the defective condition as soon after your fall as possible. After your fall, if you or your loved one can take photographs of the condition that caused your fall, it is always a good idea to do so. I'd also suggest that you report your fall to a manager at the business and to get the contact information for any witnesses to your fall. Also, another crucial action to take in a slip and fall or trip and fall case is to send a preservation letter to the at-fault party or company in your case. A preservation letter in a slip and fall case is a letter sent to the at-fault party in order to request that they preserve any evidence related to the accident. This can include witness statements, surveillance footage that may have captured the fall on the camera, and any other relevant materials. This is important because if the at-fault party is found to not comply with the preservation letter, it may give rise to the presumption that the evidence they failed to preserve was harmful to the defense of your injury claim should you have to litigate your case in court. Please know that slip and fall or trip and fall cases can be difficult cases to win. Because fall cases can be difficult, there's a good chance the company where you fell or their insurance company will fight your claim hard and not offer you a fair amount. It could be the case you must file a lawsuit in order to get a fair value for your injury claim. As such, do not delay. Highly encourage you to consult with an injury lawyer as soon as possible following your injury, so you are aware of your legal options with regard to your injury claim. I hope that you have found this video to be helpful. To learn more about the ins and outs of personal injury law, please subscribe to my YouTube channel and watch more of my videos. Lastly, if you are injured due to a fall on another person's property or business property in Kentucky, remember to don't wait, call Tate.